Good afternoon, Terps. My name is Jeff Williams, the Director of Alumni Engagement at the Smith School of Business. Today's webinar is part of the Smith School Office of Alumni Relations Professional Development webinar series. Through these sessions, we hope to provide thought-provoking and valuable content that will help alumni like you achieve your personal and professional goals. Past topics include burn the whiteboards, stop brainstorming and go ask customers these 5 questions. How to succeed in a future transformed by technology. And today's topic, employee versus independent contractor. What is the difference and why it matters? During the webinar, we encourage you to use the chat box to share any questions or comments you might have for the presenter. Please feel free to submit questions throughout the session, and the presenter will answer them as often as possible. And who is our presenter? I am pleased to introduce Patrick Hollrah. Patrick is an associate with Hollrah, LLC. He is licensed to practice in Maryland, the District of Columbia, and before the U.S. Tax Court. Prior to joining the firm, Patrick was a summer associate at T. Rowe Price and a fellow at the U.S. Chamber of Commerce. Before law school, he worked in the tax department at Ernst & Young and in the Inspector General's office for the U.S. Department of Housing and Urban Development. Patrick is a double Terp. He earned his JD from the University of Maryland School of Law, cum laude, in 2014, where he was the editor-in-chief of the Journal of Business and Technology Law. He completed his bachelor's degree in accounting from the University of Maryland, Robert H. Smith School of Business, magna cum laude in 2010. Patrick is also one of our great alumni volunteers and currently serves as a member of the leadership committee for the Smith School DC and Northern Virginia Alumni Club. I will now throw things over to you, Patrick.
Thank you, Jeff, and thank you to all the participants for attending today. Again, my name is Patrick Hollrah. I'm an attorney here in Washington, D.C., and my practice is dedicated primarily to setting up independent contractor relationships and then defending them if they're challenged. I'm also the general counsel to a coalition of companies and trade associations focused on preserving independent contractor relationships. And with that background, this afternoon, I'd like to discuss the difference between employees and independent contractors and why this difference matters to you, a business owner. So just to begin here, here's an agenda of what I'd like to cover today. I'd like to begin with who is an employee and who is an independent contractor, and then explore some of the differences for purposes of federal law and state law, and then segue into why is it so imperative to be correct. I'll discuss some of the consequences of misclassification and then discuss some recent developments. And as Jeff mentioned, there's plenty of time at the end for questions, but please feel free to ask any questions during the presentation, and I'll try to get those to you as quickly as possible. And just before I begin, I do want to just provide one disclaimer. As an attorney, I just want to let everyone know that the presentation in the Q&A portion of this content is general information, but not legal advice. But if you do have any questions, my contact information is on this slide. Please feel free to follow with me afterward, and I'd be happy to speak with you. And also a copy of these slides will be distributed afterward. So with that, let's begin. Employee versus independent contractor, what is the difference? So I thought a great way to start this off would be to begin with a hypothetical situation. We have a group of Smith School alumni, and they form a company. And this company makes widgets. The best widgets around, and business is booming. They decide they need to expand. They need to build more factories, hire more salespeople, bring in more administrative people, you name it, they need to do it. So during this discussion, some of the co-founders think about, should we hire employees, engage independent contractors? I hear independent contractors might be less expensive, and a debate begins with the co-founders, and they're really not quite sure what they should do or where they should go. And Being bright Smith alumni, as all of us are, they decide to consult their corporate counsel before proceeding. But yeah, this is a scenario that might sound familiar. I mean, independent contractors and employees, there's a lot in the media about maybe some of the differences, and all of that might not be accurate. So if all that you recall from the basics of your tax accounting class, that is okay. Hopefully by the end of this hour, I'll be able to send you back to your businesses with a better idea of who is an employee, who is an independent contractor, what are the differences, and why those differences matter. So sticking with our hypothetical here, the first thing this widget company from our former alumni would tell these individuals that employees and independent contractors are not interchangeable. They represent two fundamentally different business models, and that misclassifying an employee as an independent contractor can be a costly mistake. So who is an employee? This is something many people are probably familiar with, but at a big picture, an employee is a person who works for another person or a company. And the employee is part of the business. And some characteristics of employees include their wages are documented on a form W-2, taxes are withheld from earnings, employers make unemployment contributions, and employees are protected by state and federal labor laws. For example, the Fair Labor Standards Act, which guarantees a minimum wage and overtime protection, and then also the National Labor Relations Act, which gives employees the right to organize and form unions. By contrast, who is an independent contractor? These are self-employed entrepreneurs. These people own their own business. Some characteristics of independent contractors include performing services for their clients, not for an employer. Take, for instance, a web designer. A freelance web designer can create websites for many different clients. This person might be an independent contractor as opposed to an IT technician who works for one company in their IT department, making sure the mainframes are up and running every day. That individual is more likely to be an employee. Additionally, independent contractors, all of their earnings are documented on a form 1099. And this is where the description of 1099 workers versus W-2 workers comes into play. It's based on these IRS forms. Additionally, independent contractors do not have taxes withheld from their earnings. They're generally not eligible for unemployment, and they're generally not protected by state and federal unemployment laws. That means the Fair Labor Standards Act, National Labor Relations Act that I previously discussed are not applicable to independent contractors. And so in the tax and labor law context, an individual, the determination whether they're an employee or an independent contractor is based on the relationship the individual has with, let's say, the source of work, the employer or their clients. And so typically, if the source of work controls what will be done and how it will be done, that individual is likely an employee of that individual or company. Conversely, an individual that controls what work will be done and how it will be done is likely an independent contractor. Now, depending on the specific statute at issue, there may be some additional factors. We'll discuss those later on, but just this is a good idea, a good framework to keep in mind as we go through this presentation. So with that context, let's move on to discussing the difference between employees and independent contractors for purposes of some states and federal statutes. So just by way of background, most labor laws only apply to employees, and businesses have employment tax and tax withholding obligations only with respect to their employees. So you can see there are some significant differences between employees and independent contractors, and misclassifying an individual as an independent contractor when they should be an employee could mean that a business failed to comply with the law. And many states and federal statutes have their own definition of employee that considers different factors, so this is not a one-size-fits-all situation. You have to look at the specific facts of every circumstance to determine an individual's status. So let's begin with some federal statutes. I want to discuss three today. The first being the Internal Revenue Code, then the Fair Labor Standards Act, and then I want to finish off with the Affordable Care Act. So to start off, let's begin with the Internal Revenue Code. So for federal employment tax purposes, the Internal Revenue Code has three big provisions. There's FICA, FUTA, and then the collection of income tax on the source of wages. And for all three of these purposes, an individual is an employee if the individual has the status of an employee under the usual common law rules. So what this means is that a business has to make FICA and FUTA contributions and withhold income taxes with respect to individuals deemed to be employees under the common law test, but does not have those responsibilities with respect to individuals deemed to be independent contractors under the common law test. So what is the common law test? So for purposes of the Internal Revenue Code, the common law test is this 20-factor test that considers the putative taxpayer's right to direct and control the individual. For example, some factors the test considers are, does the business control or have the right to control what the worker does and how the worker does its job? Additional factors are the business aspects of the worker's job controlled by the payer? What does this mean? How is the worker paid? For instance, are payments per the job or are they dollars per hour? Payments per the job are more indicative of an independent contractor relationship, while dollars per hour are more indicative of an employment situation. Additionally, are there reimbursements of expenses? Generally, employees have out-of-pocket expenses reimbursed, while independent contractors do not. Another thing to consider under this factor is who provides the tools and supplies. Independent contractors usually provide their own tools. By contrast, businesses typically provide tools to their employees. And other things that are considered are the written contracts. Will their relationship continue, or is that short term? So for instance here, is the individual engaged for a specific project? Back to our idea about the web designer. Is this person creating a website one time, or is this person in the IT department continually making sure the company's products, their servers are up and running? And that's some of the differences that the Internal Revenue Code will, or the IRS will consider for purposes of the common law test. Now, moving on to the Fair Labor Standards Act, courts typically apply what's called an economic realities test to determine whether an individual is an employee or independent contractor for purposes of the Fair Labor Standards Act. Again, the Fair Labor Standards Act, this requires employers to pay their employees a minimum wage and then overtime. And so this economic realities test, it's a multi-factor test that considers the business's control plus other factors. And the overarching principle of this test is the individual economically dependent on the company? If the answer is yes, the individual is then likely an employee. If the answer is no, the individual is likely an independent contractor. And the reason for that is, going back to the theory that independent contractors own their own businesses, so they are dependent on themselves, not a client. So the economic realities test, this is the 6 factors that the Department of Labor uses. And you can see there's the control factor, that's that last bullet point, plus 5 other factors. And the first one being, is work integral to the employer's business? An example of this would be, take for instance a manufacturing business that has an assembly line that creates a product. Well, an individual who works on that assembly line, putting different pieces together, is going to be integral to that business's operation and more likely to be an employee. Another factor is whether the individual's management skills provide him or her an opportunity to generate a profit or loss. And this factor looks at more than just the individual's ability to work more hours to earn more money. Can they leverage their skills to either create a profit or potentially suffer a loss? And additionally, the Department of Labor will look at the relative investment of the individual versus the potential employer, also consider the individual's skill and initiative, and then finally, the permanence of the relationship with the putative employer. And here, the longer the relationship, the more long-term the arrangement has been, the more likely the individual is an employee. And I wanted to discuss, I move over to the Affordable Care Act. And the Affordable Care Act is a relatively unique set of laws in as much as it has 2 different definitions of the term employee within the same act. One provision of the Affordable Care Act is the employer mandate, which requires certain employers to offer eligible employees the opportunity to roll in employer-sponsored health care or pay a penalty. That provision is contained in the Internal Revenue Code, and it defines the term employee under the common law test that we just discussed. Now, another provision, this is the employer notice requirement that requires an employer to which the Fair Labor Standards Act applies to provide its employees with a notice concerning specific information concerning the health insurance coverage it offers. This provision is contained in the Fair Labor Standards Act, and it would presumably accord the term employee the same definition on them that's used for the Fair Labor Standards Act, which is the economic realities test. And so, as you saw on the past screens, these are 2 different tests. And so what this really demonstrates is that worker classification can be a complicated endeavor, certainly not one size fits all. It really needs to be examined closely before a company decides to hire an additional employee or engage an independent contractor for a specific task. And so now I want to move over to discuss some of the differences under state law. And worker status is very important for state purposes for several reasons, including taxes, workers' compensation, and unemployment. For purposes of today's presentation, I'm just going to focus on unemployment. And really what happens at the state level, states determine whether an individual is an employee or an independent contractor for unemployment purposes based on 3 different tests. Now, we've already discussed the common law test. That's a test that the Internal Revenue Code uses. And then this third test, or the statutory test, that's typically a multi-factor test in which all elements need to be satisfied to establish an independent contractor relationships. Now, I'm not going to focus on that today because only about 2 states follow this statutory test. So I thought we'd just devote our time here to examining this ABC test, which, as we'll discuss in a minute, examines an individual's control plus 2 more factors. So this is an example of a common ABC test. And under this test, a relationship tends to be an employment relationship unless it can be shown 3 factors are satisfied. The first factor is that control factor, that the individual has been and will be free from control and direction. And then there are 2 more factors. The second factor is the individual performed work outside the usual course of business or outside all of the places of business of the enterprise to which the service is performed. That's the company that the individual is providing services to. And then the final criteria is that the individual is customarily engaged in an independently established trade, occupation, profession, or business. So really what this ABC test shows is that to establish an independent contractor relationship, you really have to show that the individual is running their own separate business. And what this does, it just really emphasizes that an independent contractor relationship and an employment relationship are not interchangeable and have their own specific purposes. So before we move on to the next section, I just want you to all consider this question. Can a business choose to hire employees or engage independent contractors? And the answer to this is yes, but there's a clarification to it. The business model must be conducive to that relationship. Some business models are set up where an employment relationship makes the most sense. Some are more conducive to independent contractor relationships. And as you saw with the different tests, it really is a situation by situation analysis. In some situations, a business really wants to control and supervise the workers. Well, there it makes sense to hire employees. On the other hand, an independent contractor is ideal in a situation where a business needs a specific task completed and it engages an expert for that task. For example, the coalition I work with, we may engage a PR consultant to write a press release for us for an upcoming event, and then maybe in a few months later, use the same individual again, maybe not, maybe use a different one. That's more indicative of an independent contractor relationship. So it's important to consider all of these facts before making a decision, because as we will now discuss, getting this wrong can be very costly. So really, why is it so imperative to be correct? I think as I've hinted at this throughout this presentation, misclassification can be very, very costly. And enforcement is coming from many different angles at this time. You have states, you have the federal government, and now you also have plaintiff attorneys that know that this is a ripe area for lawsuits. And so what are agencies doing, and really what are some of the penalties? So at the federal level, you have the U.S. Department of Labor. They're enforcing the Fair Labor Standards Act, and what they can do is they can go after companies for unpaid overtime, unpaid minimum wages, unpaid reimbursements, and penalties on top of all of those requirements. In addition, the Internal Revenue Service can go after a company for unpaid employment taxes and penalties, and then also the Internal Revenue Service is responsible for enforcing the Affordable Care Act. And as we discussed, the employer mandate requires a company to either offer health insurance to certain employees or pay a penalty. And one of those penalties could be, if you fail to do so, there's a $2,000 penalty per worker, and that penalty is adjusted for inflation every year. So for 2017, it's $2,260 per worker. And the first 30 workers are not penalized, but a company with many individuals could see a huge penalty. In addition, you have states. The state's unemployment commissioner goes after companies for unpaid contributions and penalties. Likewise, the state's workers' compensation commissioner goes after the same. In addition to that, some states are making it a misdemeanor to misclassify a worker. Now, there generally must be some level of intent misclassifying the worker knowingly or willingly. Nonetheless, it still could become a criminal offense. And even without the criminal aspect, principal and interest can add up quickly, and in some cases lead companies to bankruptcy. For example, there have been stories in the news of sharing economy companies that raise millions of dollars of venture capital money that shut down because of worker misclassification lawsuits. There have also been numerous articles of trucking companies in California doing the same thing. And as we'll discuss a little later, some state and federal agencies share information with each other regarding worker misclassification, which could have the effect of leading to multiple investigations and potentially multiple penalties. I also brought up that private litigants, plaintiff lawyers, are also active in this sphere. And this is typically under the Fair Labor Standards Act, where a company failed to pay minimum wage and or overtime. At least that's being alleged by the plaintiffs. These, in often cases, are coming in the form of class action lawsuits. And you may have seen reports in the news of class action lawsuits brought by Uber drivers in California and Massachusetts, alleging that they were misclassified. And just to give you an idea about how costly some of these lawsuits can become, last year, the judge in one of the large California cases rejected a proposed $100 million settlement, saying that it was not fair, adequate, and reasonable. In this case, the plaintiff's attorney calculated potential damages at more than $850 million. And while that number may or not be accurate, again, I did not see the justification behind it, it just does illustrate how high these damages can rise. Also, in California, some of these Uber drivers filed a lawsuit under the state's Private Attorney General's Act, which gives employees the right to step into the shoes of the state labor secretary to bring enforcement actions for state labor law violations. There was also a settlement in this case. That settlement was for $7.75 million, and it was also rejected. Now, in that suit, the driver's lawyer, the plaintiff lawyer, also claimed that the violations really they amounted to over $1 billion. So again, that might be an inflated number, but just give you an idea about how large these violations can become. And really, they can have a huge impact on a company. Here are just a few other quick examples in other industries. These are all relatively recent examples. A home improvement company agreed to pay almost $3 million to 540 installers to settle a worker misclassification lawsuit. An on-demand grocery delivery company agreed on a $4.65 million fee to settle a misclassification lawsuits. And then this is just a few weeks ago, a judge issued a judgment in favor of 5 truck drivers in a misclassification lawsuit, awarding those drivers nearly $1 million. In addition, as I said earlier, several agencies have now become involved in an information sharing arrangement, and the U.S. Department of Labor has been very active in this sphere. Beginning in 2011, DOL began entering into memoranda of understanding with state and federal agencies. Currently, it has an agreement with 37 states, the Internal Revenue Service, and the U.S. Department of Housing and Urban Development. And what these memoranda of understanding are is it's typically a 3-year agreement between the U.S. Department of Labor and the state agency, or in some cases the federal agency, to share information, share resources, and conduct coordinated enforcement of worker misclassification. So now you have this situation where DOL, IRS, HUD, and 37 different states are sharing information, and that could just lead to just multiple investigations of the same instance or possible instance of misclassification. In addition, states now have also begun doing a similar type of endeavor. 17 states have established task forces to address worker misclassification. Similar to the Department of Labor Memorandum of Understanding, they are typically agreements among the agencies to share information regarding worker misclassification, coordinate enforcement, and then also recommend legislation addressing worker misclassification. And the state agencies typically involved in this would be the state Treasury Department, Unemployment Department, Workers' Compensation Agency, sometimes the state's Attorney General, and depending on the state, sometimes a few other agencies, but those are the principal ones. And to give you an idea of which states there are, here's a list of the states that have these task forces. And you can see Maryland is one of them. Now, Maryland's task force is only for information sharing, but you can see some other states have all three prongs as well. And so really what this is setting up is an interconnected system of information sharing. You have the state task forces sharing information with each other. Then you also have the Department of Labor with its Memorandum of Understanding sharing information first with the IRS, also with states, and now most recently with the U.S. Department of Housing and Urban Development. So really the effect of this is that getting it wrong once can have a cascading effect. And so I think a logical question at this point is, based on what you've said, can you win? And the answer is absolutely, and many do. In fact, many of the on-demand companies referenced have also won cases, as have trucking companies, general contractors, bloggers, product demonstrators, yoga instructors, insurance agents, and many, many, many more industries. But the key difference here is that these victories, the reason these companies were able to defend their independent contractor relationships is that their companies were designed to be able to support that model. So one of the main points I want you to take away from today's presentation is that independent contractors and employees are not interchangeable. They represent two very different business models. So before you or your business decide to hire an employee or engage an independent contractor, consider your business and then which options are best fit for your business depending on the specific need at issue. Going back to our original example of the alumni, it might make sense for the alumni to hire employees at the factories because in that instance they want to control the individuals, they want to make sure those workers are doing, they're building the widgets the right way according to their specifications. But they may want to engage an independent contractor to develop a sales brochure that their sales team will use or develop a website for a one-time project. Pardon me. And now I wanted to just move on then to some recent developments before we wrap up more of my prepared remarks for this presentation. And just so you can see, independent contractor status has been in the news and will continue to be, I think, a relatively important aspect going forward. Really most recently illustrated by the U.S. House of Representatives passing the American Health Care Act, which would repeal and replace parts of the Affordable Care Act. As we discussed earlier, the Affordable Care Act requires companies to either offer health insurance to certain individuals, to certain employees, or pay a penalty. Well, what this bill would do is effectively repeal the employer mandate by zeroing out those penalties, taking that worker misclassification risk off the table. In addition, President Trump and the U.S. Senate have each separately proposed paid leave plans. And what this does, it creates another instance where worker misclassification could become an issue. And the reason for that is these plans would only entitle employees, but not independent contractors, to paid leave. Another development is tax reform. As many of you know, the President Trump's tax reform plan proposes a 15% rate for corporations and flow-through entities. Now, this rate may also apply to independent contractors. Now, that is something that's being negotiated in Congress right now. Now, if that 15% rate were to apply to independent contractors, it could make independent contractor status preferential, certainly if the top individual rate is 35%. So you could see there will be more developments addressing independent contractors to curtail any potential for tax abuse. And then I also wanted to provide some additional resources for you in the event that you have some other questions going forward. And some great places to go are the state Department of Labor or state Department of Treasury in the states that your business operates. I'd also like to direct you to this website with the Internal Revenue Service. This is their Small Business Center. It provides a lot of great information on whether an individual is an employee or an independent contractor for employment tax purposes. And then also the U.S. Department of Labor has a relatively robust website on worker misclassification, again, determining whether an individual is an employee or an independent contractor for labor law purposes. And then I'd also like to direct you, if you want more information about state-specific developments, I only focused on some federal developments just because they would affect everyone participating in the call. You can log on to the coalition that I work with website, that's iecoalition.org, and we have a complete listing of all state bills affecting independent contractor status. And so at this point, I'd like to conclude my prepared remarks, but I'd like to now open it up to any questions that you may have and go from there.
Great, thanks, Patrick. Lots of very helpful content here. If you don't mind, I got a question here from Kathy. How is risk impacted if we allow or require our contractors to use our timekeeping system to enter their hours worked? She explains we then reconcile the time card to vendor invoice and make payment through AP.
Now, I tell you, so yeah, that's a relatively specific question, so I'm going to try to just address it more in a general sense, just so it's then applicable to everyone as well. Now, as a general matter, independent contractors, you engage them to do a specific project. You would really like them to submit an invoice to you for when the work is done, and then you pay them. You really do not want them using the payroll system that your employees use as well.
Great, thank you. Here is another question. Is there one sure way to determine whether an independent contractor or employment relationship is appropriate?
Unfortunately, the answer to that is no. Looking at the different tests that we discussed earlier today, you have the economic realities test, that's that 6-factor test that the Department of Labor uses. You have the Internal Revenue Service, that common law test, that 20-factor test. You have the states using 3 different tests as well. Some federal statutes also apply this 3rd test. This is a hybrid test. It's a combination of the economic realities test and the common law test. All of these tests consider different factors, so you really have to look at your specific facts as they relate to each of those tests to determine your relationship under each statute. And that's really, I think, one of the takeaways from this presentation is I want you to know that there really isn't a silver bullet, but it is an inquiry that you really need to look into at the beginning to make sure that you are going to have your relationship respected for purposes of the different statutes in the different states or localities that you operate.
Thank you. We have another question here from Richard. It's a little bit specific, but hopefully it's still a good question. If the worker is under H-1B visa employee, can he still open his own sole business with 1099 non-employee compensation?
Well, I'd say I do not know as much about the visa aspect of this question, but that is something that if you send me an email afterward, yeah, we can certainly follow up on that part. But just in general, an individual that wants to go into business for themselves, say they decide to incorporate or create an LLC, single member LLC, and then do business, yeah, they can be an independent contractor. But again, it all comes back to, can you establish those criteria under the different tests?
Great, thank you. I got another question. What are some steps a company can take to do a self-audit to determine whether their worker relationships are proper?
Yeah, so I'd say this is something, I think, even a lot of our clients do on their own, is periodically look at say you have independent contractor relationships currently, uh, consider how you're actually engaging these individuals. What are your day-to-day interactions with them, if any, and then look at the different tests that are applicable to you. The Department of Labor, again, their website, they have all the different steps, list all the different tests listed out, the factors, examples of them. IRS also has a similar website. And then just really just objectively look at, are you meeting these criteria or not? And if you aren't, take steps to change. But it really should be something you do periodically, because at the beginning of a relationship, you may have the best practices, but as time goes on, the relationship changes or different aspects are added or taken away, and that could change how you're engaging the individual.
Great, thank you. We'll take another couple of questions here. Feel free, as we mentioned, if anyone has any last minute questions, so please go ahead and submit them now. One more question though, what is the #1 risk to worker classification determinations? Is it from the federal government, the states, or somewhere else?
Well, I tell you, on that front, over the past couple of years, I can give you some background before we get into what happened today. Over the past couple of years, really, the #1 risk, I'd say probably maybe about 10 years ago, was from the Internal Revenue Service. Really around 2011, when the Memorandum of Understanding Initiative began at the Department of Labor, they've become more aggressive. Department of Labor, or excuse me, IRS, less aggressive. And now we have a new administration. It's uncertain really where IRS, Department of Labor is going to come, but you really do now have this emerging sense from the states that states are becoming more aggressive in pursuing worker misclassification, and you also have the plaintiff lawyers. So I would really look at the plaintiff lawyers in the states as an area not of new risk, but of more importance as they become more aggressive.
Great, thank you, Patrick. If there's no further questions, anything else that you'd like to add before we sign off for the day, Patrick?
No, I'd like to thank everyone for participating today. And again, I will send these PowerPoint slides out after the presentation. And if you have any follow-up questions, please feel free to reach out. I know some of you had some specific questions, and I really appreciate you taking the time today.
Great. We actually do have one more.
Absolutely.
One more question coming in. I think that is there any situation in which a full-time employee can also be classified or paid as an independent contractor? So, for example, if they own a side business and perform tasks or duties outside of their typical job responsibilities, from Ty.
In that situation, well, an individual should not be an employee and an independent contractor as it relates to the same company, just as a general rule. Now, could there be instances where that is applicable? Possibly. But an individual can be an employee of, say, company one, but then have a side business and be an independent contractor relative to company two. And in fact, you see that as becoming a relatively common occurrence now with the rise of the gig economy. People have their normal 9-to-5 job, but then drive for Uber or walk dogs for Rover, or pick up groceries with Grubhub. So there's certainly a possibility.
Great, thank you. And for any other more specific questions, please feel free to direct those directly to Patrick. I'll be sending out a recording of today's webinar in an email and along with Patrick's slides this afternoon, so stay tuned for that. We also hope you'll join us for our next webinar, Why You Need an Estate Plan Regardless of Your Age, happening tomorrow at noon Eastern Time. Thanks everyone, have a great day, and go Terps.